Lawyers of Reddit. What is the dumbest thing your client has done to ruin a case? Story 1. I was on a jury where the defendant showed up in court on day 1 wearing the exact same outfit as the unknown suspect in the video of the crime. It took only a few seconds before the judge immediately called a stoppage. All the lawyers went into the back with the judge, and about 7 minutes later they came out and announced that the defendant had taken a plea deal. Story 2. Not my client, but the petitioner attorney's client. The man claimed workers' compensation and threw the kitchen sink at us, basically listing just over half of his body parts on the claim petition, stating that he injured each one. He was full of it, and my firm knew it. Anyway, we were going to trial, and the day before, we ran one more social media search. This absolute idiot had posted a video of himself winning a breakdance competition just a few months after the alleged work incident. I've never seen a quicker dismissal in my life. Story 3. Not a lawyer, but I heard this story from a guy I used to work with. His brother-in-law got injured at work and was suing for a hefty sum. The case was pretty much open and shut. All the evidence was in the BIL's favor until the BIL started talking. They asked him to tell them about the day of the accident. He started out fine until he got to the part where he approached the piece of equipment that injured him. He told everyone there was a note on it stating that it was out of order. Then he said he discarded the note and started up the malfunctioning equipment because he had a job to get done. That easy win was tossed out faster than that out-of-order sign. Story 4. I'm a criminal defense lawyer. Client was arrested for DUI. He lived in a small town where he and his wife would drive to the one bar in town, drink, then walk to their houseboat afterward, about a quarter-mile away. He and his wife knew everyone at the bar. One night, another patron they knew got blasted, and the bar owner said she couldn't stay. So my client and his wife walked her to her car to wait until her ride came. Client got her into the back seat of the SUV. He was drunk, dropped the keys on the way to the front seat, then opened the now unlocked front door and turned on the car lights to see. He had walked around from the rear passenger side to the front. Cops were outside waiting to see if people left the bar drunk. They saw the lights turn on, said they had witnessed driving, and immediately arrested him. Client had a prior DUI from about 12 years earlier. The judge agreed it wouldn't come in and the jury wouldn't hear about it unless he opened the door. We couldn't win the case unless he testified. I prepped him again, and kept prepping him. I told him under no circumstances could he say he would never drive drunk, never do anything like that. Basically, nothing about the past. Direct was going well. I gave him a beautiful, easy last question where he could explain the night and why he was upset he got arrested, because he wasn't driving and was actually doing everything right. And then he said, I would never do something like that. Door opened. Judge let the DA bring in the old DUI. Jury took about 25 minutes to convict. That's just one of 100 stories. Life is never dull in the criminal defense world. Story 5. I'm not a lawyer, and this isn't my story. But the lawyer who handled my business matters and a legal dispute is now a federal judge. Before becoming a judge, he worked divorces and civil cases. A wealthy male client filed for divorce. There was a prenup, pretty ironclad. It laid out how assets would be divided, specified alimony, a fixed amount that increased yearly with inflation, and included one major exception. The exception was, if you were caught cheating, defined as any sexual contact with another person before the divorce is finalized, you automatically get the worst terms of the prenup. In the woman's case, if she cheated, she would get zero alimony and a one-time payment of $100,000. In the man's case, if he cheated, he would lose the family home, all cars except his daily driver, and a quarter of his business, with a buyout option available, though that part doesn't matter here. So the lawyer shows up at court, meets his client in a conference room, and the client is absolutely beaming. He shakes the lawyer's hand and says, Hey Mike, I want you to meet Jasmine. I met her 2 months ago. She's amazing. We got engaged over the weekend in France. Mike shook her hand, slumped into his chair, and said, So, we've got a major problem. You're cheating on your wife with her. And legally, I'm required to disclose this to the other side. The client freaks out. How the hell am I cheating? We're separated. Mike just replied, Cheating means any sexual contact before the divorce is final. It's in your prenup, the one you wrote yourself. The guy lost it. He got so angry that he ditched court entirely. That gave his wife a default judgment, which meant she got everything she asked for. And because of the cheating and the no-show, the judge ordered that all money transfers happen within 30 days, per the initial agreement. With no one there to contest it, boom. He later tried to sneak the company to his new fiancée through a trust, which was illegal. He also tried to hide money by giving her $1 million in cash via a bank transfer, but the judge found out and forced her to repay it since she had been given notice too. He fought for years and ended up losing his money, his time, his energy, his business, his house, 6 or 7 cars, and eventually his new wife. Now, since I know his daughter from work, I can tell you he's just a bitter retired man living in rural New Mexico. He can't afford to golf more than once a month, and he spends his time posting online about how women are scum. Story 6. Not an attorney, but I served on the jury for a 3-defendant murder trial. We sat through weeks of testimony, and from the sheer amount of direct evidence the state had, it was extraordinarily obvious very early on that Defendant 1 had committed the crime. Defendant 2, D1's brother, and Defendant 3, D1's girlfriend, were much less clear. The state asked us to rely on circumstantial evidence that felt like it required some leaps to reach the conclusions they wanted. That is, until Defendant 3 decided to take the stand. Her attorney did a very good job of painting her as a victim of abuse. He had us feeling sorry for this poor, unintelligent woman who had been groomed since she was 16 by a man 20 years her senior. According to the attorney's narrative, D3 was basically D1's slave. He controlled what she wore, what she did, and who she talked to. He even made her get a tattoo saying D1's name, S property. We saw texts about D1 killing D3's puppy because she had made him mad over something small. We saw texts from D3 to D1 cheering him on after he sent her pictures of a bloody knife, the murder weapon. But her attorney framed those words as her playing the role of a supportive partner so D1 wouldn't come after her next. We were starting to believe she was terrified for her own safety, and that was why she didn't report him. Clearly, this man was a maniac, and it seemed reasonable that she just didn't know how to escape. Then came cross-examination by the other defendants' attorneys and the DA. They tore her apart. She came off as argumentative, got tripped up in multiple lies, and by the end, based on her own testimony, it was pretty clear she actually did know the victim and had been the one to plan the entire murder. Honestly, we even started to feel like she may have manipulated D1 more than he manipulated her. The other defendants didn't take the stand. When we went into deliberations, we all agreed it was a huge mistake for her to testify. We decided D1 was guilty on all counts within the first 5 minutes. D3 was almost as quick. We concluded that while she hadn't physically committed the murder, she had conspired and was just as culpable. Defendant 2 took the longest. We strongly suspected he had been involved, but the DA hadn't met the burden of proof beyond a reasonable doubt. So, we had to return a not guilty verdict on all counts for him. Story 7. This guy moves into a quiet suburban island neighborhood in Montreal and immediately starts acting like he's in Texas. He fences in his front yard, gets a bunch of aggressive dogs, drives a giant truck, and builds a massive pool with a deck that covers half his backyard. The deck is so tall it towers over the hedges and old fences around everyone else's yards. Obnoxious, definitely not fitting in, but whatever. We tried being friendly. His girlfriend and daughter were nice, but a bit standoffish. He, on the other hand, shut down all interaction, which was fine. The next summer he installs a giant sound system on that giant deck. My mom has pretty bad sensory issues, so she can't be outside when the music is blasting. Unfortunately, his family had a habit of leaving it on full volume while they went inside, or even left the house completely. So my mom politely asked him to turn it off when not in use. He completely lost it. In retaliation, he bought an even bigger sound system, mounted it on his roof pointing directly at our house, and blasted it at max volume 12 hours a day. At that point, even with the windows closed, it was triggering my mom's sensory issues inside. So she started documenting everything. She filed noise complaints regularly, but when the cops came, they only checked the front yard and didn't see the setup. He retaliated by playing his music louder. My mom wasn't intimidated, so it just escalated. Finally, 2 female officers showed up, came to our house, and confirmed it was way too loud and clearly malicious. They checked her log and decided it was harassment, so they went to talk to him. When they knocked on his door, he told them to get off his property. They explained they had every right to be there and just wanted to issue a warning. He responded with sexist slurs and set his aggressive dogs on them. The officers retreated to their car and wrote him up for assaulting a police officer. They also contacted the SPCA. The SPCA investigated and discovered he had too many dogs, was breeding them illegally, and neglecting them. Neighbors told them they'd seen him beating the dogs, but he had threatened them to stay quiet. The SPCA seized his animals, cited him for animal cruelty, and passed along the threats to the police. The police questioned more neighbors and learned he had been dumping pool water into another neighbor's yard and threatening her so she wouldn't report it. They logged that and contacted Bylaw about the pool. Bylaw showed up and found his deck and front yard fence were completely illegal. He was fined and forced to take them down. On top of that, the police spoke with his girlfriend and daughter and uncovered domestic violence. They connected them with resources, and they left him. He contested everything, so it all ended up in multiple courts. His first lawyer tried to play games with scheduling to discourage witnesses. But that doesn't work against a retired couple, my extremely motivated mom, and our paralegal neighbor. He fired that lawyer, lied to the next one, and it backfired. Eventually, he represented himself, and it went as badly as you'd expect. Last I heard, his girlfriend got the house, and the whole ordeal cost him a fortune. Unfortunately, she did take him back, but she seems to be in charge now. He's still odd, but he's not hurting anyone anymore, so nobody cares. And that's how one idiot turned a noise complaint into a life-ruining mess. Story 8. Civil attorney here. Social media is a plague on litigants, but it's usually more beneficial when I can use it on the defense and when my own clients actually follow my instructions. Not talking about the other side's clients and their social media. Here are some of my personal favorites from my own side. I represented a client against the city because the bus driver she was riding with didn't wait for her to sit before pulling away and then slammed on the brakes. She had hidden the fact that she'd been in a car wreck 3 days earlier from me. But in her deposition, she admitted she was following her niece's advice to claim the bus, rather than the car wreck, caused her injuries because there would be more money. I fired her the next day. After hours of prep telling a client not to go into details about the facts leading up to his criminal charges and convictions, just to state the dates, alleged offenses, and judicial disposition. He volunteered in deposition that what had been pled down to a relatively inconspicuous misdemeanor, public indecency, actually stemmed from a years-long sexual relationship with his sisters, where they got caught by a mall cop. I took over a case from another attorney involving a bicyclist who was hit by a Lexus in a red light shouting match. The previous attorney had done virtually nothing, no depositions, incomplete discovery responses, missing huge portions of medical and billing records days before jury selection. My pitch was simple. Drivers must never needlessly endanger others by drinking and driving, disregarding traffic signals, failing to pay attention, etc. My client knew this was my angle. Then he testified and basically admitted he did all the same reckless things, only on a bicycle. I had a personal injury client who insisted on driving his Corvette to trial every day, despite me telling him not to. To make things worse, he actually cut off one of our jurors in the parking garage. And one social media-related gem. I represented a 22-year-old on probation for assault who'd been in a commercial vehicle wreck with horrific property damage. A miracle no one was killed. Within weeks, and after being advised not to use social media, he posted videos of himself smoking a blunt and drinking 40s with his cervical collar half on, plus multiple pictures posing with cash and firearms he wasn't supposed to have. He violated probation, picked up another charge for attempted robbery, got no further medical treatment, which destroyed his damages model, and then wondered why I dropped his case, especially after he admitted he hadn't been wearing a seatbelt in the wreck, where the driver was intoxicated and there was an infant passenger. Story 9. One of the first and only divorce cases I took as a solo attorney was for a man who claimed his wife had run away back to Nepal, abandoning him and their 7-year-old daughter in the States. He said he had no way to contact her, no way to find her, and that she was probably with a new lover. So we served her by publication, filed everything with the court, and the case was rolling along uncontested until the wife showed up with her own lawyer and proved that her husband knew exactly where she was the whole time. He even admitted to me via email that he may have been a bit deceptive. I told him that if he was willing to be completely truthful moving forward, We could work with his wife's attorney to negotiate an agreement, but that it would now be a contested divorce, meaning he'd need to pay me more since his small retainer for an uncontested case had been depleted. He refused to do either. I also had zero faith he'd stop lying, and he quickly gave me more reasons to believe he wouldn't. So I informed him I could no longer represent him. I filed for a mandatory withdrawal of representation due to fraud on the court. At the motion hearing, he stood up and objected. He told the judge I only wanted to withdraw because of money, then tried to hand over every single communication we'd ever had to the court. He had printed out all our emails. His wife's lawyer looked at me, then told him that if he handed them over, they'd also get access to everything. So maybe that wasn't such a great idea. Wife's lawyer was fantastic. The judge was dumbfounded. I simply said it was a mandatory withdrawal and that giving any further explanation would prejudice my soon-to-be ex-client. The judge briefly tried to explain to him what that meant, then granted my motion. He finally shut up, and I walked out. Story 10. Testify. I had a criminal client charged with being a felon in possession of a firearm. These cases usually aren't hard for the prosecution. They typically call two witnesses. 1. The arresting officer to establish the person had the firearm and to introduce it into evidence. And 2. Either a probation, parole officer to prove the defendant was a felon, or a fingerprint expert to match the defendant's prints to a prior indictment. The only thing we had going for us was that the gun was found in a very heavy coat my client was wearing that had his nephew's name on the tag, and my client's statement at the time of arrest that the coat wasn't his. And while not exactly helpful, the gun was a small .22, so I could at least argue with a straight face that he could have put on the coat without realizing the gun was in the pocket. I made a bit of theater out of it. Had the coat brought over from the jail with the evidence tag still attached, asked the arresting officer to take the gun out of the evidence box. Please clear the weapon. Officer, we don't want to endanger the good folks of the jury. And drop it into the coat pocket so the jury could see it didn't weigh the coat down much at all. I figured we had an outside shot at a not guilty, but more likely we'd get a compromise verdict like attempted possession. That was, until my client decided I hadn't done a good enough job explaining his version. That he was protecting his nephew by holding the gun because his nephew was fighting with his baby mama and was going to shoot her if he had it. He insisted on testifying. I told him flat out he was an idiot. All of this happened at counsel table after the state had rested, with everyone waiting. The judge excused the jury, and I asked him to question my client on the record about whether he understood his Fifth Amendment right not to testify. The judge did, and my client confirmed he knew nobody could force him, but that he still wanted to tell his story. And tell it he did. A long, rambling mess. The DA's cross was brutally simple. Is this the jacket you were wearing? Yes. Is this the gun that was in the pocket of that jacket? Yes. And you knew that gun was there, right? Yes. The jury convicted him in less than half an hour. Story 11. I'm a lawyer, and honestly, I could write a book about this. Most of the dumbest things happen when I'm out of the office or in trial and can't stop my clients from screwing themselves over. The most common, lying about small, easily verifiable things on the stand. It destroys their credibility completely. We know you didn't pick up your child from daycare every single time. The daycare has a log, and your mom signed the kid out half the time. We know you filed multiple restraining orders on your spouse. It's electronic public record. Second most common, changing their story on the stand. I can prepare for the facts as you told them to me. I can't prepare for things you never mentioned. Third most common, completely ignoring advice. I told you not to take that $150,000 out of the bank account because there would be repercussions. Cue contempt. One time, there was a court order to sell the marital home. The house was actively listed with a realtor. My client decided to put a padlock on it so no one could access or sell it. Contempt again. Another client. After 5 years of fighting, I finally got her custody of her kids. When she went to pick them up, she brought a known violent felon with her, carried a loaded gun, and got into a physical fight with the children's guardian. Emergency petition was filed, and the kids were removed from her care. She had custody for less than a week. Then she had the audacity to call me a bad attorney in front of the judge because the kids were taken away. The judge literally laughed and told her I had won the case for her until her own actions caused the reversal. He let me withdraw on the spot. Story 12. Not a lawyer, but I was working closely with our company's legal team. One guy at my company claimed he fell off a ladder and seriously injured his back while working alone against company policy, with no witnesses, and while doing a task he wasn't even supposed to be doing. Still, we had to take the claim seriously. All the paperwork was filed. He was sent to doctors and specialists, the whole process. We ended up putting him on light duty in the office, just handling paperwork and parts ordering. He was working part-time, but still collecting full paychecks. This went on for months. He kept claiming he wasn't getting better and even started filing complaints about how he was being treated in the office. He said the chairs hurt his back more, claimed he was being bullied, and piled on excuse after excuse. He insisted his injury was so severe he couldn't sleep properly, had trouble using the bathroom, and that his life had been completely changed. Injuries like this can really screw a company and block us from certain projects, so it was a big deal. Then summer rolled around, and I went to a softball tournament with some friends. Guess who was playing? That guy. I watched him swing a bat multiple times, sprint to run bases, dive for catches, and slide into bases. I got a couple of videos and immediately called our legal team. Sent them the footage. Case was closed very shortly afterward. I truly couldn't believe how shitty and how unbelievably stupid some people can be. Even if he actually had been injured, you can't tell doctors you can't sleep because of back pain and then be out there swinging a bat and sliding around the very next weekend. Story 13. I had a woman I arrested who asked for a probable cause hearing. The charge was escape. She'd cut off her GPS anklet and run, and PC hearings for this kind of thing were really uncommon. Usually, only brand new public defenders tried them, except in certain defense strategies for more serious cases. Point being, there wasn't much reason to have the hearing. She cut the anklet off. We had the anklet as evidence. Case closed, basically. But not only did she want the hearing, she demanded to testify. Her public defender, a fairly new one, strongly advised against it. He even brought in another PD who had a good rapport with her, since she was very familiar with our criminal court system, and that attorney also told her not to do it. Nope. She wanted her time on the stand. The hearing went forward. Before it even started, the judge himself strongly advised her not to testify. She did anyway. Her testimony was that her boyfriend had taken her against her will and forced her to cut off the anklet, blah blah. I was called up as a witness and presented screenshots from her Facebook account showing her smiling, hanging out happily with her boyfriend and daughter, all time and date stamped, of course. Obviously, the judge found probable cause that a crime had been committed, and the case was sent to the grand jury for indictment. But having a judge flat out tell a defendant that testifying was a bad idea, that was a first for me. Story 14. Not a lawyer, but I worked in digital forensics for a bit. As part of my training, I looked at an old case. It was connected to a famous one Reddit definitely knows about, so I'll keep this as vague as possible. Our role was working for the defense of a public figure accused of knowing about some bad behavior by people under him. State criminal investigators had imaged his computer and claimed they found deletion software, which they said proved he was erasing relevant data to cover himself. The DA even held a big press conference announcing the indictment. I had a good amount of help desk experience, so when I looked at the names of the supposed deletion software, I immediately recognized them as basic malware that had just snuck onto his system. Then I reviewed the paperwork from the 2 times the state investigators examined his computer image. The hashes were different. For context, a hash is basically fancy math you run on data that produces a unique string. If you run it multiple times on the same dataset, you always get the same result. If the hashes are different, that means either A, they were looking at 2 different datasets, so the results aren't valid, or B, someone tampered with the data, making it unreliable in court. And this was me, a newbie, just getting into the field. The real investigators had far more substantial issues to raise in court. In the end, the DA quietly cut a deal with the guy. He wouldn't work in the industry in that area anymore, and he'd get a payout of about 1.5x his yearly salary. No press conference for that part, just quietly sweeping the errors under the rug with enough money to make it all go away. Story 15. Not a lawyer, but I served on a jury in a state where the jury sets the punishment and can decide whether to convert it to probation. Our instructions were that we could also recommend probation. The charge was criminal enticement of a child. In this case, the child was 16 or 17, and the defendant, who was in his 40s, had been grooming her and giving her very expensive gifts. He was already a registered sex offender, but had served his previous sentence. We were instructed that the defendant wasn't required to testify. The prosecution's case overall was weak. The girl didn't testify, and most of the evidence was hearsay. A few witnesses claimed they'd seen them together, but that was about it. Then the defendant decided to testify. His lawyer looked visibly uncomfortable announcing it, and the judge made sure he stated in open court that he was waiving his right not to testify. And then this guy basically became the prosecution's star witness. He came clean and declared that he loved the victim and that they were engaged to be married because he had given her a ring. We gave him the full 10 years, no probation. Honestly, we wished we could have given him more, but that was the maximum sentence for the charge. Story 16. I had a client lean back in the witness chair at trial and prop his feet up on the witness stand. On top of that, even though I specifically asked him not to bring up his shoe size, for some reason it was his favorite topic, he still announced that he had size 14 feet. I strongly suspect he showed up after drinking that afternoon. Needless to say, the judge found him completely lacking in credibility. I had another client turn down a settlement process that began with the highest opening offer I've ever seen. Millions. An amount that was higher than what the client himself had previously said would be his final acceptable number in negotiations, and far more than he could ever hope to get at trial. I had yet another client settle his case without involving me at all, for much less than I could have gotten him. It was baffling. Lately, I've noticed a real uptick in clients trying to override my advice, acting like they know better about legal strategy even though they don't know the first thing about evidence or civil procedure. And why would they? They haven't had the training. It feels like a low-grade revolt against education and expertise. It's been pretty demoralizing. Don't get me wrong. I love good questions and genuine debate. But at the end of the day, why hire me if you think you already know better about how to litigate a case? Story 17. Not a lawyer, but I was a cop. I arrested a guy for underage DUI. He called his dad to witness his breathalyzer test, and his dad called a lawyer, who ultimately advised him to refuse the test. At the kid's first appearance, the defense attorney asked me what I could tell him about the case. I said, well, in the breathalyzer room his dad called a lawyer, not sure if that was you, and asked for advice. I could hear the conversation, since we were only about 3 feet apart. I heard the lawyer ask, do you think he'll fail? And the defendant's dad respond, absolutely. The defense attorney just gave a quiet, and walked away. The kid ended up pleading guilty to DUI in exchange for dismissing the other traffic charges, running a red light, and I think driving left of center or something like that. Story 18. I had a client whose first language wasn't English. I knew this, and so did the opposing attorney, who, to his credit, was decent and not obnoxious about it. For the deposition, we arranged for a translator, but my client was absolutely insistent he didn't need one. After multiple discussions, we finally agreed to proceed without. My client could converse in English just fine with me, and I never had trouble understanding him. I prepped him thoroughly and made it crystal clear. If he didn't perfectly understand a question, he needed to ask for it to be rephrased. We get to the deposition. About an hour in, my client gets asked a series of questions he clearly doesn't understand. Instead of asking for clarification, he answers anyway and basically undermines his own claims. I asked for a break, but under the rules, opposing counsel was allowed to finish his line of questioning first. OA didn't push it too far, but he finished enough to do damage. During the break, I told my client it was basically over. While in theory we could try to rehabilitate him, there was no way that testimony was going to play well with the jury. We ended up settling for half of the initial, already low, offer. Ever since, if I have a client insist that's strongly on going without a translator, I make them put up an extra retainer, even in contingency cases. Story 19. Not a lawyer, but I was directly involved in an ongoing case where a client was charged with attempting to sexually assault a clinician with a witness present. He was given a conditional suspended sentencing deal. If he refrained from any sexual misconduct whatsoever for 1 year, he wouldn't go to prison or be labeled a sex offender. Instead, he'd remain under state custody for 5 years in his current psychiatric treatment facility. The judge laid out in detail what counted as sexual misconduct. Any unwanted sexual advances, verbal, physical, or coercive, sexual contact of any kind with clients, since they couldn't consent, breaking the facility's sexual behavior rules, possession of illegal pornography, e.g. CP, snuff films, voyeurism, exhibitionism, basically anything beyond privately masturbating in his bedroom with the door closed. About 2 months in, he decided it would be a good idea to proposition a staff member for nudes. When she shut him down, he tried to threaten her with a fake formal complaint. We reported it to the state, and he went back to court. He tried to plead not guilty by reason of insanity, but the judge immediately rejected it because of a recent psych evaluation that confirmed he was competent. The judge reminded him that prison time was very much on the table, at least 5 years, and made it clear he was out of patience. Instead of locking him up right then, the judge gave him one more chance, extended his probationary period to 2 years, slapped him with a dangerous mentally ill offender (DMO) designation, and told him if he slipped up again, he'd get the maximum sentence. After that, he technically complied, going so far as to refuse to work with female staff entirely, even though he hated male staff more. As far as I know, he's still carrying the DMO status, and it's likely he'll have it for a very, very long time. If you enjoyed the video, don't forget to leave a like and subscribe, activate the notification bell, and share a similar story or anything you'd like to say in the comments. See you next time.